The Supreme Court was yet again the focus of the country as it made a landmark ruling to abolish Section 204 of the Penal Code, which states that any person found guilty of murder, robbery with violence, treason and other capital offences shall be sentenced to death by hanging. The judges, led by Deputy Chief Justice Philomena Mwilu, Justice Njoki Ndungu and Jackton Ojwang, declared that the provision is harsh, unjust and unfair as it compromises the chance to a fair trial.
The mandatory nature of the death sentence as provided under Section 204 of the Penal Code is hereby declared unconstitutional.
Section 204 of the Penal Code deprives the court of the use of judicial discretion in a matter of life and death. Such law can only be regarded as harsh and just.
A case challenging the constitutionality of the death penalty, the Apex Court was however quick to observe that the decision to abolish the mandatory death sentence for murder does not mean the sentence to death by hanging is not applicable.
The avoidance of doubt, this order does not disturb the validity of the death sentence as contemplated under Article 26, Sub-Article 3 of our Constitution.
Any court dealing with the offense of murder is allowed to exercise judicial discretion by considering any mitigating factors in sentencing an accused person charged with and found guilty of that offense.
Instead, the court ordered the Attorney General, Director of Public Prosecution and other relevant agencies to prepare a detailed professional review in the context of the judgment and set up a framework to deal with the resentencing of those on death row. The Attorney General will then submit a progress report to the court within 12 months' time.
We direct that this judgment be placed before the Speakers of the National Assembly and the Senate, the Attorney General and the Kenya Law Reform Commission, attended with a signal of the utmost urgency for any necessary amendments, formulation, and enactment of statute law to give effect to this judgment on the mandatory nature of the death sentence and the parameters of what ought constitute life imprisonment.
In the case, two death row convicts, Wilson Thirimbu Mwangi and Francis Karioko Maruatetu, who have been in jail since 2003, had petitioned the court for a retrial and further wanted the court to do away with their mandatory death penalty.
We have perused and analyzed the petition and written submissions, and it is clear that the petitioners have not sufficiently argued and illustrated the particulars of why the indeterminate life sentence should be declared unconstitutional. Indeed, counsel for the first petitioner, upon being asked by the court to elaborate on the issue, was not able to provide adequate submissions.
It is prudent for the same court that had this matter to consider and evaluate mitigating submissions and evaluate the appropriate sentence befitting the offense committed by the petitioners. For the avoidance of doubt, the rehearing sentencing we have allowed applies only for the two petitioners' hearing. In the meanwhile, existing or intending petitioners with similar cases ought not to approach the Supreme Court directly, but await appropriate guidelines for disposal of the same.
The landmark ruling could conceivably change the legal landscape and tear down barriers that have existed for over 121 years since the colonial government introduced the death penalty in the country. Kenya now joins 139 other countries under the United Nations to abolish the death penalty in law. However, there have been no executions in the country since 1987, with those sentenced to death serving lifelong jail terms unless pardoned by the president. Ben Chumba, reporting for Channel 1 News Hour.